Hello, everybody. Bruce from Oregon here with the Bruce from Oregon Show. This is episode 0. It might be the first, it might be the last. We don't know. In today's episode, we are going to have a premiere instead of a pre-show live stream for The Bachelor or Bachelorette. In this premiere, I am joined by ASCII Moose. Up here, I've got a notepad and some fixed width fonts. And we have a little moose that I drew. And what we are going to do today with Mr. ASCII Moose is something kind of interesting. I reviewed pages 1 to 20 of the appellate's opening brief in the Owens v. Eckerd paternity scandal. So this is the petitioner's opening brief, and I took some notes. Now, these are only layman's notes. I'm just a human-shaped moose. I'm not a lawyer. This is not legal advice. I'm not really interested in nitpicking the facts of the case. I'm not really interested in nitpicking case law. But what I want to spend a few minutes on today are the mechanics of the first 20 pages of this filing. The grammar, the logic, the syntax, the use of the English language, the economy of words. All of these type of things. So we'll get into that. I took about 26 notes. And I didn't do that on purpose. Shout out Rule 26. But that's what I've got. So let's get into it, shall we? The way I have this listed is the page number from the PDF that you get from the courthouse and the issue number, 1 through 26, of the issues that I have with this document. Hello, everybody. Editor Bruce here with a quick note. I don't think you can go to the courthouse in Arizona and just get a PDF, like on a flash drive. I think you get paper documents, and then somebody has to go get those paper documents and take them and scan them and make a PDF and hand them out to the rest of the world. So to all the people that have done that, kudos to you. And let's get back to the content. All right, thanks. So let's get into it. 7.1. So the beginning is kind of like tables of contents and title pages and things like that. So the interesting things start around page 7. And on page 7, he, and when I say he for each of these items, I'm talking about the petitioner's lawyer who wrote the filing. He says, the case presents some bizarre, interesting, frightening, and salacious facts. Now, he starts off, rather than just presenting the facts, he starts talking about the facts using all these subjective adjectives. So if I were to sharpen my moose antlers and get the red pen out and review this document, this is the first thing I would fix. And we'll see this all throughout the document. There are a lot of these superfluous adjectives all over the place. And when I am trying to be precise, when I am trying to communicate clearly, I think a lot of these adjectives can just be removed because they're just an opinion. Like, are there salacious facts? Maybe. Maybe to somebody else they're not salacious. These are just opinions. And what I'm really interested in is a recap of the case facts that matter to this appeal and the arguments about what is going to matter in the appeal. And subjective adjectives do not add anything to the information that I could get out of a tight, well-written appeal. Okay, so that's number 1. Number 2, he says the cast includes an inexperienced trial judge. I would remove the word inexperienced because, again, that's subjective. There's no objective definition that I can use here that I know of to determine whether a trial judge is experienced or inexperienced. So I would remove that. 7.3. He says the judge broke the law to ensure a Pyrrhic victory. Again, around the word Pyrrhic, this is another subjective assessment. Somebody else might disagree. It's not that he can't put in all of these subjective adjectives. It's just that I don't think there's utility in them. That's my opinion. That's not how I would have written this document. That's not how I would recommend somebody write a document like this. Okay? Continuing on with 7.4, he says the strange facts of the case are almost irrelevant to this court's task. Now, guys, when I see the phrase almost irrelevant, what it tells me is the logical equivalent is relevance. And it's no surprise that there are facts of the case that are relevant to the appeal. So I don't know why he writes this sentence this way. It's very awkward. The other thing is he says the strange facts. Well, strange is another subjective adjective. I would have removed that as well. 7.5, he says at the end of the day, to begin a sentence. Now, at the end of the day is an idiom. And when I searched for this on the internet, I learned that at the end of the day is an idiom that was voted most annoying cliche by the Plain English Campaign Group. Now, I have no idea who the Plain English Campaign Group is, but they sound like a good group of people to me if they had a survey where at the end of the day was voted the most annoying cliche. Kudos to them. Okay, 7.6. He wastes time here. He spends a bunch of paper time, paper space and words out of his word count, asking and answering if the rules of procedure matter or if the rules can be casually tossed aside, calling his own question rhetorical. Okay, so if you have to call the things you're talking about yourself rhetorical, just omit them. Like, you're wasting your time. Like, we all agree rhetorical questions are rhetorical. Like, the tautology is sound. Okay, item 7.7. He claims it is indisputed that. And now, when he says that, okay, I have to explain. He says that is the rules adopted by the Arizona Supreme Court matter, and all judges, all lawyers, and all litigants must follow them. And then his claim is it is undisputed that did not happen here. Now, this is a very strong claim that it's undisputed, that there's literally no one that disagrees with this claim. And from my position reading this document, given that there will be a response to the appeal by the respondent, I would assume that they disagree with this claim, that it is undisputed. Okay? So, to me, this just appears to be speculation. And I would go through this document and try to find all these places like this where there's any sort of hint of speculation and remove it. If you want to state something as an opinion, my recommendation is to state it very clearly that it is your opinion. And when you are stating matters of information or matters of fact or things you believe you know, those will be stated differently. So, for example, it is my opinion that chocolate ice cream is better than strawberry ice cream. Now, that's a very different statement than the strawberry ice cream and the chocolate ice cream are in my freezer. That is a statement of information or a statement of fact, whereas the prior statement was a statement of my opinion. And I think when we're communicating with other human beings, the most important thing we can do is to try and be very clear about whether we are talking about an opinion or speculation or a statement of fact. All right. Okay. Let's keep it moving. 8.8. So we're on page 8 now. There was a lot on page 7, guys. Oh boy. We're on item 8. He claims plentiful and egregious factual mistakes. Now, egregious, to me, this is another subjective term, so I would have removed that. And then plentiful here is qualitative instead of quantitative. Like, is 3 plentiful? Is 10? Is 100? We don't know. So we've got some qualitative statements. We've got some subjective statements. I would remove those words and just try to be more clear. Okay. 9.9. He claims Laura learned she was pregnant by taking a home pregnancy test, or HPT. My problem with this is that home pregnancy tests are indicators of pregnancy, but they are not exclusive proof of pregnancy. So, for example, a headache might be an indicator of a brain tumor. But if I have a headache, it doesn't mean I have a brain tumor. I could have a headache for a variety of reasons. Similarly, there could be other legitimate reasons for why a home pregnancy test or a blood HCG test would register positive while the person is not clinically pregnant. So ignoring these other options seems to me to be sort of like speculating and omitting other options, maybe a false dichotomy or, a single answer type of thing and ignoring all the rest. I think that's a little disingenuous. Okay, 1110. He claims a 102 blood HCG test on October 16th was bad news. The term bad news here is really subjective. It's qualitative. It's emotionally charged, okay? Because when you think about a miscarriage, this is a horrible thing that can happen to a person. And there is going to be, a serious emotional response to that. So to just sort of say bad news, number one, he's trying to imply that that's what's happening here. It's a specific interpretation he's directing you at as a reader. This one, like the previous one about the home pregnancy test, ignores other potential alternatives. For example, if someone was never pregnant, or if they were committing some sort of pregnancy fraud, then a 102 blood HCG test wouldn't be bad news, or at least it wouldn't be bad news in the same way that's described here. And these items, 9.9, 11.10, I think these are sort of the crux of the conflict in this case. In terms of what is reasonable in terms of evidence before you will believe a claim, a pregnancy claim or a paternity claim. And in looking at these things, I try to have a skeptical mindset and I try to have a scientific mindset. And from science, we know that a home pregnancy test or blood HCG test on its face is an indicator of pregnancy. It is not exclusive proof of clinical pregnancy. Okay. And we would need a paternity test to determine paternity from, I don't know, a medical perspective, a chemistry perspective, a science perspective, not from a personal testimony perspective of, well, so and so must be the father because they're the only person I've fooled around with. Maybe. It's hard to convince skeptics without sufficient evidence. Okay, I'll just say that. Let's keep going. 1111. Make a wish. 1111. He claims the October 16th blood HCG test indicated Laura had either miscarried or that a miscarriage was inevitable. Now, to me, this is a false dichotomy again, because this excludes other legitimate possibilities for this blood HCG test, like incidental, accidental, or fraudulent HCG within a person's system. Because he's excluding these other possibilities, it's sort of like it's sort of like a deceptive debate technique. You're saying it was either A or B, and you're just sort of brushing aside options C, D, and E. And in science and in logic and in reason, we can't brush aside all the other potential possibilities just because those are inconvenient. We have to take those into account and try to rule those out using evidence. Okay, 12.12. He claims the 2 negative pregnancy tests at MomDoc on November 14th means she was no longer pregnant as of that date. This is it's like the false dichotomy problem again, but just with one answer. Another valid option here is that maybe she was never pregnant to begin with, because then you could have 2 negative pregnancy tests at MomDoc as long as there was no HCG in your system anymore as of November 14th. Since clinical pregnancy was never established in this case, and the default initial starting state of human beings is not pregnant, when I see a negative pregnancy test, it doesn't tell me that somebody was pregnant and now they're not. It just tells me that on November 14th, she had 2 negative pregnancy tests. That's all it tells me. It doesn't let me imply anything else about it. Okay? 12.13. He claims after November 15th, Laura had no case-related contact with Clayton. I thought this was a little suspicious because she had a publicly available Medium blog on December 8th, which is after November 15th. And somewhere around December 8th, she called Scottsdale PD claiming Clayton violated her order of protection. These activities, or these actions, or this publicly available information, or this indirect communication to Clayton through the police department, I consider all of these potentially public case-related contact, even if it's indirect. So when he said no case-related contact with Clayton, I think what he was trying to say maybe is there was no more communication through the court docket. There was no more communication through lawyer emails. But his claim here is fairly broad compared to that. So I think if that's what he meant, he needed to be more specific here when writing this item. Okay. Number 13.14, he claims following the Rule 26 motion, the record becomes a confusing and contradictory mess. Well, first of all, the word confusing is subjective. What is confusing to you might be not confusing to someone else. Or I don't know what it means for something to be confusing to you, the writer of this document. Sorry, it's just subjective. Now, in terms of contradictory, he appears to argue that the motion to dismiss was both granted and denied, creating a contradiction. In logical terms, this would be A is true and A is not true at the same time. And I've written that down here with this terminology, A and not A. Okay. He describes granting Laura's motion to dismiss on January 24th as A, right, and denying Laura's motion to dismiss on February 21st as not A, which is the contradiction I think he's talking about. I could be wrong, but that was my interpretation of reading this. Now, my response to this is that it ignores a more detailed interpretation of these details and the motion to dismiss. So the motion to dismiss related to one subject, paternity, was granted on January 24th. On the other hand, the motion to dismiss on the subject of fees and sanctions, which is a different subject, was denied on February 21st. Now, to me, and again, I'm not a lawyer, I'm just looking at this logically. Given that there are two different subjects within a larger motion, A and B, paternity and fees and sanctions, where A is not equal to B, then we can conclude that A and B, as a statement of logic, A and B both being true, is both valid and sound. So to me, it's okay. Let's see, item 15. He claims matters then became even more convoluted and confusing. This is just more subjective language, guys. Given that court documents are available to the public in the temporal order of the docket publication dates, I'm really not sure why he's so confused. You can go read a new court document off of the public docket, and if you need to refer back in the past to other documents, you can. So I don't know why he would be confused by that or think that others would be confused. Item 16. He claims on May 28th, the court issued yet another confusing order, and also says, inexplicably, the court concluded. So both confusing and inexplicably here are subjective language. I mean, just because he doesn't understand why the court concluded something doesn't mean it's inexplicable. Maybe it's inexplicable to him. I don't know. But I wouldn't include it in the language of a document I was writing to try and explain to someone issues about the case, my arguments about the case, the law about the case. I don't know. I think these subjective adjectives are very unnecessary. Item 17. He claims at the end of May 2024, with nothing left to decide, the court still held an evidentiary hearing on June 10th, 2024. Now, it seems like he's saying he doesn't understand why the hearing occurred because, in his mind, there was nothing left to decide. Now, clearly the hearing happened, and the judge let the hearing happen. So clearly the judge had a reason for letting the hearing happen, had something to decide, or wanted more information in order to make another decision. If he simply just doesn't know why the hearing was scheduled to occur, it doesn't mean that the hearing should not have occurred. And I think in this appeal, he's trying to convince the appeal panel that the hearing should not have happened. And I just don't see the logic here. This is an appeal to ignorance. He's saying, I don't understand something, therefore, the thing that happened is wrong or shouldn't have happened. And that's a fallacy. So it's just, we may not know why the judge still held the hearing. Or, we'd have to go back to the documents and try to figure it out. But just saying, I don't think there was anything left to decide, so it shouldn't have happened. Well, you're not the judge. So it just doesn't make sense. Item 18. He says the trial court issued a lengthy, and at least he's quantitative here, he says 19-page decision. But instead of just saying 19-page, he says lengthy, which again is subjective. I don't know what the objective measure of a decision is and how to determine if it's too lengthy or not. Seems like an opinion. Now, if he's saying like, well, often decisions in family court don't need 19 pages, if there's some sort of anecdotal evidence or you have an opinion, like I just think 19 pages was lengthy for this specific document, that's certainly a valid opinion. And it's certainly reasonable commentary to have. But I don't know how commentary that he could have is really going to be substantive to his appeal brief. Now, if a third-party commentator with a linen shirt were to refer to a motion to appeal filing as lengthy, or if a third-party commentator with short shorts were to refer to the entire appeal process itself as lengthy, to me, that would appear to be reasonable commentary, in the court of public opinion. I just don't know why an appeal brief requires this kind of subjective commentary. I would have removed it. Okay, item 19. He claims that many of these findings in the decision are either directly contrary to the admitted evidence or supported by no evidence of any kind. Now, the only item offered as evidence of this claim that I could find appears to be the Planned Parenthood is not open on Sundays text information that was in the decision. Now, he walks through this later on page 18, which is very good. The problem is, this is only one example. It's not many of these findings. Many is, it's qualitative again. It's not quantitative. How many findings are contradictory or supported by no evidence? Can you enumerate them? Can you walk through each one and talk about your arguments? That's what I would rather see than some of this superfluous language. Okay. I mean, the other problem with this here that I wrote down was that this text about Planned Parenthood not being open on Sundays that was in the decision was already reviewed and ruled on in the Judge Fisk decision after the Judge Mata decision. So when he says it's supported by no evidence, I mean, I don't know. It was ruled on. So at least there's evidence of a ruling. I guess there's evidence of two rulings. Now, you may say that those rulings have no foundation, but that's not really what he says here. He's just saying they're supported by no evidence. I don't know. It just seems like very imprecise language that he's getting into here on page 15. Let's keep going. Page 15.20. He claims the court again recognized Laura's argument that Rule 26 sanctions were inapplicable because Clayton failed to comply with the procedural requirements of Rule 26. Now, I think he's making a big assumption here. I don't see a motion withdrawal as being the same thing as a compliance failure. My understanding back when this was occurring was that the motion withdrawal was really done to save time to avoid litigating on this specific issue to prove that they were right. It wasn't done because they realized they had a compliance failure. They just wanted to save time and argue about fewer things, which is perfectly reasonable. So he's trying to point this out and say it was an explicit admission of failure when I don't think there's evidence of that. I think there's written evidence to the contrary. Anyway, on page 17, item 21, he claims supporters, which is plural, claimed Mr. Howe told them, and them again is plural, of course, and said, among other things, "Dad, come here, you have got to see this." And he has a quote, "Dad, come here, you have got to see this." Now, I was there, and my understanding is that only one person, which is singular, verbally said those words and said that someone said those words to them. So that is one person or one direct testimony witness, not supporters plural and not them plural. In grammar, this is a subject-verb agreement error. And I don't know if he's doing this on purpose or if this is a mistake, that he's implying that more than one witness, had direct testimony about this quote, or if there are more than one witnesses that had direct testimony about this quote. I don't know who they are. So to me, this seems like a problem. 17.22, he claims one of the most critical factual findings was not based on the evidence admitted at trial. So again, he includes the word critical here, which is subjective, and we all know by now how I feel about subjective terminology. In addition, the Fisk decision said that this Planned Parenthood statement was of little to no importance given the rest of the findings. So there at least appears to be a disputed opinion here between him and Judge Fisk rather than a statement of any fact. And he doesn't state it as an opinion, he states it as a statement of fact. One of the most critical factual findings was not based, or one of the most critical factual findings. It seems like a disagreement, and maybe his opinion is that this issue is very critical. And in that case, what I would do is I would start to behave more like Hemingway, and I would write two different sentences instead of one sentences. One with the statement of fact. If this text was never in any evidence admitted at trial, I would say that in one sentence. And then if my opinion was that this is a critical factual finding, I would say that in a second separate sentence where it's very clear that it's my opinion. Okay. So that's how I would write this. 1823, he claims, it appears the only basis for the court's finding, and again, he's talking about the Planned Parenthood is not open on Sundays text, was social media posts published online after the trial concluded. Again, this is speculation. He's ignoring all the other potential ways that information could have made it into the ruling. Now, I agree with him that we don't know how it got into the ruling, and Judge Fisk did not explain it either. So I don't know how we can figure that out, because I would love to know how that got into the ruling. But we don't know. The answer is, I don't know. And what he does here is he says, it could have happened this way, so I am just going to assume it happened that way and start talking about it as if that's the most likely answer. It appears that the only basis. Social media posts published online. Maybe. I think he's speculating real hard here and crossing his fingers, hoping nobody worries about the other ways that this information could have gotten into the ruling. I don't know. 1824, he claims this extraordinarily serious misconduct by the trial judge. Again, this is subjective. Extremely serious. Okay, that's your opinion. Personally, I think he should be allowing the panel of judges or the bar or this JCC he made complaints with or the county attorney determine if there was misconduct or crime. It's not his place to pass judgment in a filing. Okay, 1825. We're almost done, guys. This is amazing. He claims his affidavit of counsel is extensive. Again, that's subjective. What does extensive mean? I don't know. Did he file an affidavit of counsel? Okay, just say that. I think he could learn a lot by just thinking about the old, when they tell you about newspapers and newspaper reporting in like fourth grade or whatever. And they're like, at the start of your newspaper article, you put who, what, where, when, how. And if you want to get into the why, you can. But I feel like in this appeal document, you really need to focus on those other things first. Because when we start getting into why, if we're talking about other people, as opposed to talking about ourselves, we're probably speculating. And I think speculation can be dangerous. And this gets into the final item here, 1826. He claims Judge Mata's denial for the new trial may have been retaliation. Okay, so he's starting to get into a why question. And I think it's a little dangerous because I think he's speculating. He uses the words apparent act of retaliation. So, the only good thing I can say here is that in these last couple of examples, he at least tries to give himself a linguistic out by saying things like, it appears the only basis for the court's finding, or an apparent act of retaliation. But he only starts doing this at the end of this section of the document as opposed to the beginning. And I don't know. And again, what I would try to do is really separate out when you are making a statement of fact, keep it in its own sentence. And when you are speculating, keep it in its own sentence and make sure everybody knows you're speculating. It appears, or it is possible. Like, it is possible that something happened. Or if you have an opinion, keep it in its own sentence as well. I like chocolate ice cream better than strawberry ice cream. I think this potential misconduct could be very serious. My opinion is that this action is very serious. There are ways to write where you can be very clear about whether you are making a statement of fact, an opinion, or speculation. And in engineering documentation, as an aside, when you are making commands, for example, if you are writing instructions and or a specification, and you are telling someone that they must do something in order to be compliant with your specification or your instructions, that is a very different thing than if you are telling someone that they may do something optionally. So in technical writing, we use very specific words and very specific sentence construction to differentiate between opinions, statements of facts, optional commands, mandatory commands, and speculation. Okay. And again, in this 1826 item, he says, he uses the words apparent act of retaliation. Again, this is speculation that ignores any other non-retaliatory reason that could explain why the denial for the new trial was issued prior to the resolution of the notice of change of judge. There could be a litany of other explanations. And he does not speculate about those. He only speculates about the ones that are good for him. And maybe this is common in legal filings. Maybe using a lot of subjective language is common in legal filings. I don't know. But if I was an editor, if I was a reviewer, if I was holding a red pen on a draft of this document, these are the 26 things that I would recommend fixing in this document. All right. Hopefully that was interesting. Hopefully we learned a few things. Hopefully, some of these things will stick in the back of people's minds when they're working on their next writing project or working at their job, managing their teams, whatever they happen to be doing. All right, guys, if you've stuck around this long, thanks for hanging out. I'm Bruce from Oregon, Bruce the Moose. This is the Bruce from Oregon show. Let's take one more look at our friend ASCII Moose. Thank you for your time, guys. I will talk to you later. Bye.